That's a very interesting question. If you want to learn who is making all the laws, there is something called delegated legislations, and it's a very interesting chapter from administration law. So please sit and wait for my entire class so that you can learn what is delegated legislations.
Hey guys, please subscribe my father's channel.
So Nishan is going to learn from my today's class what is delegated legislations. Let's not waste any time. Let's get into the first slide to understand what is delegated legislations. In my first video, I am going to explain you the meaning, reasons for growth, classification and types of delegated legislations. In my next class, I will be explaining the advantages, disadvantages, purpose, etc. of the delegated legislations, and I will make one independent video on the important case laws that you can refer for delegated legislations. So this is a series of video but all small videos so that you can go one by one and understand the terms very clearly. With that, let's get into the first slide. First thing first, let us try understand the meaning of delegation. Imagine on a Sunday morning you are reading a newspaper and your father comes and asks you to bring 1 liter milk, and you, instead of bringing it, you asking your son to do the same. Now your father has delegated his responsibility to you and you are further subdelegating your responsibility to your son. That's what exactly happens with legislature also sometimes. Instead of doing all the legislations by itself, it transfers its right of making legislation to executive, and all those laws or rules made by executives are called delegated legislations. And sometimes executive authority also transfer its responsibility to the junior executives, which is called subdelegation, on which I am making an independent video in future. So I hope the concept is very clear. When the legislature transfers its power of making legislations to the executive, and when executive makes it, those legislations are called delegated legislations. Now it can be an independent law or a rule to existing law. If you want to increase the weightage of your answer, you can bring the name of Salmond along with his theory of supreme legislation and subordinate legislation. Now where can we see this? The Article 123 of Indian Constitution gives the power of making ordinance to the President of India. Now who has to make the legislations? It is legislature's job, and President is the part of executive. But when the parliamentary assembly is not, or parliamentary session is not happening, at that time if anything to be released, President has the right to release the ordinance. That's where we can see delegated power from legislature to executive. With that, let's move on. Let us try understand the reasons for the growth of delegated legislations, why they are so popular. First thing, Parliament time is so precious. If Parliament starts making all the laws, regulations, rules, schemes, then it cannot make. That's first thing. And Parliament time is so precious that it cannot invest all its time only making legislations. That's very important. That is why the delegation is very important, and that's why it is growing faster and faster. Second thing, technicalities. Now Parliament is full of politicians, but laws will have medical related facts, engineering, sky, earth, science, technology, everything comes. So Parliament will not have that much of knowledge or information on each subject. So it is essential for Parliament to take the support of executive, which will have sufficient personnel who have experience and knowledge on that particular aspect. So it is very essential to take the support of executive to use that technicalities or give clarity on those technicalities. Third one, flexibility in like clauses like Henry VIII clause and other stuffs, which gives lot of power to the administrative part to amend the existing rules or laws, to add or to remove the required part. So that gives so much flexibility to the administration. Now you might be thinking, what is Henry VIII clause, which I am going to explain in my future slides, so don't worry too much on that. Then administration can do a lot of experimentation, but the legislature cannot do that much of experimentation. That's why the delegated legislations are growing faster and faster. And during emergency or during local scenarios, or to increase the speediness, or for the benefit of public interest, or action involving discretionary or unforeseen contingencies, all those time executive has more open to the people than the legislature, because for legislature to reach those people it takes a lot of time, but executive is already working with those people. Like particular locality or particular section of people or some public interest required in some particular place, all those can be addressed by executive quickly, so that the legislature delegates the power to the executive, and executive successfully implements all those amendments or rules or bringing new schemes, or like ration scheme and other stuffs are basically came from executive. So that's how it is growing faster and faster. The next important aspect is classification of delegated legislations. Now they are basically classified into 5 categories. They are title based delegated legislations, discretion based delegated legislations, purpose based, authority based, and nature based delegated legislations. Now what are title based delegated legislations? If any rules, regulations, bylaws, notifications, schemes, orders, ordinance, directions, etc. is delegated from the legislature to executive, those are called the title based delegated legislations. Now if there is any condition or contingent involved, in that case those are called discretion based delegated legislations. Now conditions like you can do this and you cannot do that, all those stuffs are condition, and contingent only for the time being as a midway if something is taken by executive, those are called contingent. Those are all called as discretion based delegated legislations. Now purpose based is like the legislature is bringing some legislation and executive can decide the timing of the implementation and on whom it is applicable and for whom it is not applicable, or for which place it is applicable and for which place it is not applicable, or for few people so and so articles are applicable and for few people so and so sections are not applicable. All those stuffs can be decided by executives, which is called purpose based delegated legislations. Now authority based or subdelegation, for example legislature is delegating it to executive and senior executive authorities are further delegating it to junior executive authorities, which is called authority based or subdelegation. Now subdelegation is an independent topic. I'm making an independent video on that because there can be an independent question on this, so don't worry too much on that as of now. The last thing, on exceptional cases there can be nature based delegated legislations also. These are the 5 classifications you need to remember. The last part of this presentation, I am discussing the types of delegated legislations. Now there are 4 types of delegated legislations. They are normal, exceptional, Henry VIII clause, and finality or exclusion clause. In normal delegation, there are again 2 types, positive and negative. If legislature gives clearly defined work to executive to make any delegated legislations, those are called positive, and negative like legislature restrict the executive to not to make any laws on tax related matters or amendment to the parliamentary made laws or any amendment to the Indian Constitution itself. Those are called negative delegated legislations, like you cannot make anything on that. Now second part discusses about exceptional delegation. There are 4 important aspects which I am reading out: to magistrate on matter of principle or to impose taxation, the power to amend parliament, the power conferring discretionary power on a minister, and parliament forbidding judicial control. These are on exceptional conditions only. Now third one is Henry VIII clause. Henry VIII was a 16th century king of England, and he told executive that if you face any difficulties, you can add or delete any of the provisions of a particular law to ensure that the implementation of such law is happening smoothly. Now there is a lot of criticism also on Henry VIII clause, which I am going to discuss when I'm discussing the case laws. And the last part is finality clause or exclusion clause, where executive gets a right to make, amend, addition or deletion on a particular law which cannot be questioned in court of law also, which is called finality clause or exclusion clause. In my next class, I am going to discuss the purpose, advantages, disadvantages of delegated legislations, and there will be small presentation on subdelegation, and I will also make independent video on the important case laws when it comes to delegated legislations. With that, I am concluding this class. Thank you so much for watching me. Please subscribe my channel. Please like, share and comment my videos. All the very best for your exams, and thanks again.